to. Please, a round of applause as he comes. More on him, we can see that on page 9 of our brochure. He spoke to us yesterday. Please, another warm round of applause as he comes forward.
A good morning to all of you today. I don't know whether there are any people that were not here yesterday, or everybody that is here today was here yesterday. Are there any who were not here yesterday? So my presumption that we have people that were only able to make it yesterday but cannot come today must be correct, because we're much fewer. Anyhow, once again thankful for having been given this opportunity to come and share with you our own experiences back in our country. And today, as I deal with the question of jurisdiction and the constitutional safeguards and the delays in the criminal courts, I would want to start with an overview of the framework, the constitutional and legal framework that we have in Kenya in connection with criminal cases, or generally in connection with the criminal justice system. And let me start by saying that we have a constitution that was promulgated in the year 2010. And before 2010, we had another constitution, which largely was like the constitution that we got at independence in the year 1963, but with a number of amendments in the course of time. So we are saying that for a period of about 47 years, we had a different constitution from what we have today. But thankfully, in the old constitution, just like in the new constitution, a number of things were guaranteed as fundamental rights. And those included the right to a fair hearing, the right to a public hearing, of course with exceptions relating to the question of public order, national security, morality, the case of vulnerable persons, although that had not been recognized under the old constitution. This came in 2010. The right to be tried within a reasonable time. That's the way it was phrased in the old constitution. But in the new constitution, it was phrased slightly differently, and I think it's important to take note of the nuanced phraseology, because in the 2010 Constitution, this right was the right to have the trial begin and conclude without unreasonable delay, as opposed to just the right to have the case tried within a reasonable time. And I will say why I think that this is a nuanced or a different, slightly different approach to the management of criminal cases. I will be speaking about that later. Now, there was, of course, the presumption of innocence. There was the right to detailed information of the nature of the offense charged. There was, again, still as a fundamental right, the right to adequate time and facilities to prepare one's defense, and also the right to legal representation. The right to legal representation included the right to includes the right to self-representation, and the right to facilities to examine witnesses called by the prosecution and to call witnesses on the same conditions as those applying to the prosecution, which is a part of the equality of arms principle in criminal cases. Perhaps just one a quick point that I did not mention is that when we had exceptions to the right to a public hearing under the old constitution, those, particularly the exception that a public hearing could be denied on the grounds of public order and national security, that was often abused. And there were what I would call kangaroo courts that would often be held that would then result in the violation of human rights of accused persons. Now, flowing from the new constitution, which I have mentioned the guarantees on, there is an addition that was not there before. And this is the recognition of victims in the criminal justice process. Before 2010, but more particularly before 2014, because in 2014, that is when we got statutory legislation in the name of the Victim Protection Act 2014. Before then, the criminal justice arena recognized only the judge or magistrate sitting in the middle, up front. Then on one side, the prosecutor, and on the other side, the accused person. And when I say the prosecutor included as an appendage the complainant. And then on the side of the defense, the accused person and his or her lawyer would be there. And the rest of the people in court would basically be, in a manner of speaking, page boys and flower girls. Now, today we have in Kenya recognition of a distinction between a complainant and a victim, so that the two terms do not necessarily have to inhere. They do not have to coexist always. The complainant could be, in a typical case, the complainant can be my son or my daughter, but the person that might have been victimized might include them and myself. And that is a very important distinction because it then has allowed us to practice criminal law in a way that, in my view, enhances the quality of justice. Because before then, the victim was not entitled to have any right of audience in the court. Now, under the Victim Protection Act, there is the right of audience. So what used to happen is that we would, in a great many cases, be hired by the complainant also, because the complainant would be fearing that the prosecutor might cut deals with the accused persons, the accused person, and that the complainant therefore could lose a case that they had reported and gotten into the court process, not because of any other reason, but because the prosecutor